Okay, thank you everybody for joining us today. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. Today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. And there are quite a number of options you can choose from. Just a few things before we get started. So Scott Legal is a full-service immigration law firm, which means we do have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. This means whatever your immigration needs may be it a family-based matter, employment-based matter, or investment-based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least 2 webinars a month on different topics related to immigration law. So please feel free to sign up for any upcoming webinars in the future. And at the end of this webinar, we will be sending out a few things to all participants. First, we will be sending you a copy of the PowerPoint that will be used in this webinar. Second, we will send you all a visa guide, which is a comprehensive guide to the visa categories that we will be speaking about today that you can use as a resource. We will also send you a link that you can follow to sign up for the additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button, as we do regularly upload a variety of resourceful videos about immigration law. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your particular case further. So today we are very lucky to have Kelly Weiner, who is a partner of the firm with a wealth of experience handling cases in the visa categories that we will be speaking about today, who will be presenting about these various options available to individuals with extraordinary ability in their fields and the requirements and strategy considerations. Finally, for any questions you may have, you can add them to the chat box or use the Q&A function to submit your question, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, Jiyae. So we can get started today. We're just talking about a couple of the major extraordinary ability categories, both temporary and permanent. So the first ones we'll talk about are the temporary, visa categories. So these are appropriate for people who want to come and work in the United States, and just want to stay for, a short period of time, versus the green card options that we'll talk about later are for people who really want to live and work in the United States permanently and make the United States their main place of residence where they're primarily residing. So let's talk about the O-1A visa. So this is a non-immigrant, meaning temporary visa, for people who have extraordinary ability in the sciences, education, business, or athletics. And the standard is a person who has risen to the very top of their field. So it is quite a high standard, to meet this, this qualification. Then we have the O-1B visa. And so this is for people with extraordinary ability either in the arts, and there's a separate kind of category for people with extraordinary ability in motion picture or television industry. So that's all under the O-1B, but there's slightly different standards for adjudication if you're doing arts versus if you're doing motion picture or TV industry. So for the arts, the person has to have achieved a level of distinction, a high level of achievement, evidenced by skill and recognition substantially above that ordinarily encountered. So these are for people that are prominent, leading, or well-known in the field of arts. And then as the standard for motion picture or television industry, you have to show you've reached a level of acclaim substantially above that of your peers. So for the for the arts standard, distinction versus having risen to the very top of your field, it is slightly easier to meet the O-1B standard than it is to meet the O-1A standard. So that's to say that if there is a category where it's a little bit unclear whether it should fall under arts or business, things come to mind like modeling, tattoo artists, anyone kind of in a field that's maybe emerging or developing where it's not super clear, if it is possible to apply to make an argument that this it should be encompassed under the arts, then it may be favorable to go with an O-1B visa. So the last one we'll talk about, and we'll talk about each of these in a bit more detail, is the EB-1A green card. So this is a permanent category for people that want to live and work in the United States permanently. The standard kind of mimics the O-1A. So someone, a small percentage who's risen to the very top of their field. and has demonstrated sustained national or international acclaim, you know, and is coming to work in that field of endeavor. So if you're coming on the EB-1A, you do need to, you know, include a statement explaining that you're going to continue to work in your area of extraordinary ability. And then for the O-1A or the O-1B, you're often going to submit either an itinerary or a work contract showing that you have work in your area of specialty for the length of time that you'll be granted the visa. One last one to just mention very briefly is the National Interest Waiver green card. So this is not normally, not always thought of you know, in the same, you know, area as extraordinary ability, but it is kind of adjacent to the extraordinary ability green cards because it really is for people who, you know, maybe are really doing excellent work in their field. Maybe they haven't quite reached the EB-1A standard, but maybe they're working on an endeavor, you know, that's so important to the United States and that they have had so much success in that field that they can then proceed with a green card application based on that. And Jiyae will talk a little bit more about the national interest rate waiver requirements later on in the, you know, in the presentation. So you can move to the next slide. Perfect. Let's dig a little bit more into the actual requirements for the O-1A visa. So for the O-1A, you either are going to demonstrate that you have won a major award, such as a Nobel Prize, a Pulitzer Prize, or much more commonly, people are qualifying, showing that they meet at least 3 out of these criteria, you know, listed here. Ideally, of course, you're going to put in as many as you know, as you have, but at least 3. So we have here, you know, receipt of prizes or awards, you know, memberships in associations in your field which require outstanding achievements, published material about you or your work in major trade publications, newspapers, or major media, original contributions to your field, authorship of scholarly articles in kind of major journals, high salary in comparison to others in your field, participation on a panel or as a judge of the work of others in your field, and employment in a critical or essential capacity for organizations you know, that have a distinguished reputation. So when you're looking at these criteria, you want to think about, you know, not just what is every prize or every award I've ever won in my life. You want to be thinking about, you know, not only, you know, do I have this prize or award, but is this a nationally or internationally recognized prize or award? You know, is this directly related to my area of extraordinary ability? Is this a student award? So for example, you know, very often if you know, if you're in your bachelor, you know, earning your bachelor's degree, maybe you won some awards like you know, those types of things that are awarded only to students are generally not going to be strong for this type of application. That being said, if while you are a student, you win an internationally recognized prize or award that is, you know, not just you know, given to students, but is just, you know, part of your, you know, being in your industry, that certainly could be used. The fact that you are you know, the fact that you won the prize while you were a student doesn't disqualify using it. You know, but you do want to be thinking strategically about what to include. So you, even though you want to include evidence for as many categories as possible, you don't want to include evidence if it's going to weaken what your overall profile looks like. You know, so for example, if you're a member in an association, you know, but anyone can join as long as they, you know, have a bachelor's degree in that field and pay a yearly fee, that's not the type of evidence they're looking for the O-1A. You want to think strategically about, you know, every piece of evidence I include, even if it meets the criteria, when they do their analysis at the end, because they're going at the end, they're going to do a holistic analysis. Does that help build up my profile to show that I'm an individual who is one of the small percentage who've risen to the very, very top of my field? So you always want to be thinking with that in mind. You can go on to the O-1B. So for the O-1B visa, you can see the structure of the, you know, criteria, you know, is very similar to the O-1A, but it's just more arts focused in how the, you know, criteria are described. So for this one, it's going to be either, you know, nominated for, received a significant award like an Emmy or a Grammy, or evidence of at least 3 of the following listed here. And you can see that these are much more focused on what would be applicable to people who are working in the arts. You know, it may be a situation where if you, again, are in one of those niche fields or those developing fields where maybe there's not the same metrics that you would normally see if you were applying as kind of, you know, a movie actor or something like that. There is this category for other comparable evidence. You know, not for people in the motion picture industry, but if you are in the arts, again, if like, let's say you're a tattoo artist or something like that, like if there's other evidence you could include it, but you do need to show essentially that these other categories are not applicable to you, or include, at least 3 of those categories, and then include other evidence and argue why this should, be included. So you may need to make some kind of creative arguments, especially if it's a developing field, or a field where there's not kind of these same traditional metrics they think of when you think about, what would make someone a successful artist. All right, so let's talk a little bit about what are the differences between the O-1A and the O-1B. So we've touched on some of these. So O-1A, again, is for sciences, education, business, or athletics. O-1B is for the arts and motion picture or television industry. The standards are different. The O-1A standard is going to be higher, that small percentage who's risen to the very top of their field. O-1B is going to be distinction, and motion picture or TV, acclaim substantially above that of your peers. They're issued for the same length of time. So for O-1A or O-1B, that's the same. You can initially get your visa for 3 years. And then if you're just extending kind of the same set of projects, like let's say you are, kind of an actor and you have multiple engagements, and now, there's some reshoots going on or something. Like if it's just an extension, then maybe it's just for 1 year or just for the length of time of the reshoots. However, if you have like a whole new employment project, a whole new like kind of employment contract, or a whole new set of projects with a new itinerary, you can also make an argument, to get an additional 3 years. And there is no cap on how many times you can get these renewals. You can get them as long as you have, work in the United States that is qualifying under the extraordinary ability criteria. And the question, can your family come to the US? Yes. So your spouse and any unmarried children under 21 can accompany you. Unfortunately, the spouse cannot work. However, both the spouse and the child can attend school. All right, so we just got finished talking about the O-1A and the O-1B, which, as I mentioned, are temporary visas. So, somebody is primarily going to live outside the United States, but has specific employers or agents within the U.S., or foreign agents who are, have a relationship with U.S. agents and is going to come and do work in the U.S. temporarily. That's when the O-1A and O-1B would make sense. If you're in a situation where you think, I want to be living in the United States permanently, I want to be working for, whoever, whoever I want to work for in my area of extraordinary ability, then you would want to consider the EB-1A green card. So the standard for the EB-1A is very similar to the O-1A and O-1B. So we haven't listed all the criteria here because they're essentially the same, slight differences because this category does encompass the arts as well. So science, business, education, athletics, and the arts, they're all kind of part of the EB-1A category. But we wanted to talk a little bit about the Kazarian analysis. So this is a very important, analysis that is done for EB-1As and then also for O-1A and O-1B, where they're going to look at, do you meet the plain language of the regulatory criteria? So if it says, membership in associations that, require outstanding achievements of their members, they're going to look and see, okay, we have proof that they're, a member of the, this particular trade organization that does require more than just kind of a yearly fee. There are, some specific metrics and requirements people need to meet. And they're going to do that for all of the various, different, documents that you submit to see, do they meet these regulatory criteria? But then in the second step of this analysis, they're going to look at what is the quality of the evidence. So in totality, looking all together at what has been submitted, when we're making a final determination whether to approve this case or not, is this someone who seems like they've risen to the very top of their field of expertise? So that's where, again, going back to what I had mentioned previously, you want to be strategic about what evidence you include. It is not always the best, course of action to include every single thing you've ever done in your career. You want to be thinking about, how am I going to be leaving the officer with the overall impression, that I am somebody who's, very, very much at the top of my field. And so you want to be thinking always about kind of that narrative, and is each piece of evidence you're including helping build towards, that kind of final determination the officer is going to make. So now we're going to switch gears a little bit. We're going to talk about the national interest waiver, which can be a great option for people that maybe aren't quite at the EB-1A standard yet. And Jiyae is going to walk us through that visa type.
All right, thank you, Kelly. So yeah, let's talk a little bit about the EB to NIW. So the first thing to note is yeah, who qualifies for the EB to NIW, right? And before actually going into that, it is worth noting that the EB to NIW is one of the few categories that allow for self-petitioning, similar to the EB-1A green card option that Kelly just mentioned in the previous slide. The EB to NIW does allow for self-petitioning, which means the beneficiary, the foreign national himself or herself, can drive the petition forward, as opposed to, the other traditional methods of employment-based immigrant visas, which require a U.S. job offer, which require a U.S. Company to sponsor the beneficiary. So let's talk a little bit about how you can qualify for the EB to NIW. So the first thing to note is the threshold requirement to qualify under the EB2 category, which is the minimum before even going through the three-pronged national interest waiver criteria. So let's look at how you can meet the EB2 category. So you can meet this either by showing that you have an advanced degree, which is defined as a master's degree or higher, above the baccalaureate level, or its equivalent. So the equivalent of an advanced degree would be a bachelor's degree in your field plus 5 or more years of progressive work experience in your field that is post-dating your bachelor's degree. So if you have a bachelor's degree in your field and 5 or more years of progressive work experience, you can be considered as someone who has the equivalent of a master's degree or higher in your field. Now, it is worth noting that the definition of advanced degree also includes things like a JD degree, a Juris Doctor, or an MD degree, a medical doctor degree, things like that. Even though that's not technically a master's, you do need to have a bachelor's in order to gain admission to those types of programs. So that is also included in the definition of an advanced degree. A similar argument goes for an MBA, which is, a very common degree that we see that entrepreneurs have. If you have an MBA, you can use that to qualify under the advanced degree threshold. Now, before I move on to exceptional ability, I want to say one more thing about progressive work experience, right? So when you say 5 years of work experience, what do you mean 5 years of progressive work experience? It means that your job duties and your responsibilities have changed over time, increased in seniority and increased in complexity over the 5 years. So if your job duties stayed the same, if you did the same thing for the entire 5 years, your salary didn't change, if your job title didn't change, then it would be difficult to make the case that you have 5 years of progressive work experience, because what USCIS wants to see is something that's evolving over time. So if you are trying to qualify with a bachelor's degree and 5 years of progressive work experience, a very important piece of evidence you want to include is the employment confirmation letter from your previous employers that not only confirms that you have 5 years of continuous full-time work experience, but also that your job duties change in complexity and seniority over time. Now, the other way of qualifying under the EB2 category is by showing that you have exceptional ability in the sciences, arts, or business. So if you go through the route of exceptional ability, you actually do not need to show that you have a master's degree or its equivalent. So this can be a good alternative, especially for people who are considered to have extraordinary ability in their fields, right? So the way to show exceptional ability is to meet at least 3 out of the 7 criteria that is enumerated here. And those criteria include things like 10 years of full-time work in your field, which can be proven by employment confirmation letters, official related, academic records showing that you have degrees or diplomas in the field, even if it is not a bachelor's, even if it is not a master's degree, you can still use those kinds of academic credentials. Evidence that you have a high salary, you hold a high salary, as compared to others, that can also be helpful. But the really important thing that you want to focus on here is showing that you have evidence that you were recognized for your outstanding achievements in your field of endeavor, right? So here it says the criteria says recognition for your achievements and significant contributions to your field by your peers, government entities, professional organizations, or business organizations. And that can take a variety of forms. And this is where some creative lawyering can really help your case. For example, have you developed new technology in your field that resulted in the publication of a patent? And publication of a patent itself could be one form of evidence that your work has been recognized as something that is innovative, that does push the field in your endeavor. So you could use that. Have you authored, any papers that have been cited a high number of times? That could be evidence of your academic achievements that were recognized, in the form of independent citations? How about media articles written about you? If you're an entrepreneur, if you have, founded a successful startup, has it been featured in TechCrunch? Has it been featured in, press releases elsewhere? Or can you get a government agency to really speak to the merits of your work? So things like that. You can really be creative in what kinds of evidence you can include to really show that you have received recognition for your outstanding achievements in your field and your contributions to your field. So if you can convince the government, and the standard is this, they're looking for a degree of expertise significantly above that is ordinarily encountered in the field, right? So you can see that it is a little bit of a lower standard than the EB-1A standard that we discussed in earlier slides, which requires someone to be of a very, very top of a profession. But to meet the exceptional ability standard, you only need to show that you are operating at a level that is significantly above what is ordinarily encountered. So that can definitely be a more reachable standard for many people. Now, however, the important thing about the national interest waiver is that the inquiry does not stop at the threshold. The inquiry does not stop at the exceptional ability, threshold. You do need to convince the government of the three matter of Danosaur factors to qualify for the NIW, which is a privilege that is granted. It's an exception that is granted. Whereas, in the ordinary situation, you would, normally need a U.S. job offer. You would normally need the U.S. employer to go through what is called a labor certification requirement, which is, the employer needs to test the labor market to see if any other U.S. worker is available to take your position. But if you qualify for the NIW, you're exempt from that. So what the government is wanting to see is the three-pronged matter of Danosaur criteria. That first, your proposed work in the United States has both substantial merit and national importance. Second, that you yourself are well positioned to advance the proposed endeavor that has that importance. And third, that on average, it would be beneficial to the United States to exempt you from the requirements of a labor certification because of the outsized benefits of your work and your unique know-how and your irreplaceable skills. So just to go through the three-prong criteria in a little bit more detail. What does it mean that an endeavor has substantial merit and national importance? It really means that the government is looking for, something that will result in progress and social benefit in, a wide variety of fields. And the fields can be as varied as business, healthcare, education, science, and technology, even in culture and art. If you can show that your work can have a broad impact in really improving the status quo in those areas, you can make an argument for substantial merit and national importance. And work that is, that tends to further human knowledge in those key areas, right? For example, medical advances, for example, improving manufacturing processes, civil engineering, these kinds of things, where you're really pushing the envelope further on, the status quo of the industry, that can be very favorable in meeting this requirement. Another way to meet this requirement is to show that your future work in the United States tends to bring a strong positive economic impact to the regional economy, to the national economy, right? And so really the question that you want to ask here is, what can you argue is the future impact of your work? And how can you argue that it would be important to the United States as a whole, as opposed to just benefiting your immediate employer, as opposed to just benefiting your immediate clients? So if your work really tends to impact the field more broadly, then it really could be a good candidate for a national interest waiver. The second prong is showing that you yourself are an individual who is well positioned to advance the endeavor that we just developed here. And this can be proven by, showing your education, showing your experience, really showing that you do have a record of success in previous related projects, relevant to the proposed endeavor. And the third prong, on balance, the fact that it'll be beneficial for the United States to waive the requirements of a labor certification for your particular case. You can argue this in a variety of ways. You can rely on prong one, emphasize the broad systemic benefits to the field as a whole. You can also rely on prong two, really emphasize the unique know-how and experience that other U.S. workers with minimum qualifications may not have. And finally, for entrepreneurs, you can rely on some special considerations, right? So for example, if you can show that your work will offers substantial positive economic benefit to the United States, such as job creation and generation of tax revenues for local governments and the federal government. That could be a very positive factor, a balancing factor that can help your case. So now let's shift gears a little bit and talk a little bit about expert opinion letters, which are an important part of all of the visa categories that we talked about today. The O-1A, O-1B visa categories typically have expert letters as a part of it. The EB-1A EB-1A immigration petition also has expert letters as a part of it. And for the NIW that I just mentioned, expert letters play also an important role. Now, the purpose of these letters would be a little different based on the type of petition that we're going for. For example, if you are applying for an O-1 visa or an EB-1 immigrant petition, you would want these experts to confirm that you do have extraordinary ability in your field. And you do want these experts to confirm that you are a well-known figure, such that you have sustained national and international acclaim in your field. Regarding the letters that we would submit in support of NIW petitions, some of these letters we can get to really emphasize the national importance of your proposed endeavor, such as a letter from a government agency official that can really discuss what you're planning to do in the United States and why it stands to impact the field more broadly. And some other letters that we can use for the NIW petition can focus on the second prong, well-positioned. So those letters can talk about your own contributions to your field in the past and how this makes you well-positioned to advance your proposed endeavor. So this can include letters from previous employers that confirm your leading role in a particular project that resulted in a broad impact to the field. And that can really help drive the narrative forward. For entrepreneurs, some entrepreneurs find it helpful to get a expert letter from an economist who can write an evaluative report on the economic impact, the prospective economic impact, and the indirect and direct job creation that can result from the applicant's proposed endeavor, that is, running a successful business. Now, let's talk a little bit about who would be writing these kinds of letters, right? So you don't necessarily want to just get a letter from someone who is your colleague, who knows you, from school or something like that. Really, the key here is to search for leading experts in the field that have decades of experience, that really can, position their opinion as a reliable expert opinion for USCIS to rely on. So it is very common for us to also enclose a full curriculum vitae, a full-length resume of each expert who is providing the letter that the USCIS officer can see, really to really boost the credibility of the opinions that they share. With regards to the O-1A, EB-1A, and also importantly for the NIW, sometimes we look for people who have senior positions in leading institutions. And for the NIW in particular, officers who serve in a government organization could be especially helpful in confirming things like what is in the national importance and is the applicant well positioned to particularly drive forward this cause, in a special way that is superior to, what you would ordinarily encounter. So we typically look for people who are involved in a senior capacity with such leading organizations in the United States to really help drive forward that argument. Another consideration is, how does the expert letter referee know you? So in this case, we typically recommend that you have a mix of independent experts and what we call inner circle experts, right? So independent experts are people that you haven't directly worked with you before, but they know you through your work and through your leading reputation in the industry. And they can confirm in an objective way that your abilities are outstanding in your field, or that your work stands to impact the field more broadly. And USCIS tends to trust these opinions, a little bit more because they're coming from an independent source. Now, inner circle experts are people who have worked with you and can speak to your achievements in the past in a more informed way because they were either personally involved in that particular project in a more intimate way. So those kinds of letters can really flesh out the narrative of what you have done that is different from others, and what was the impact of your past projects, that can really help drive the extraordinary ability argument or the national importance argument. Now, what should be the content of the expert letters? It is important to note that specificity is very important. So letters that are, tend to be formulaic and tend to repeat the regulatory requirements tend not to be so effective. For example, if the letters just say, oh, the applicant is a well-known figure, or if you just say, oh, the applicant's, project has national importance, that on its own will not be enough to convince USCIS. We really need to include concrete details on how does your work set you apart from others and why were these achievements important to the industry. For example, what was the limitation that the industry had been seeing, and what did you do that is different from others that really helped push the envelope and solve these industry-wide problems. Those kinds of concrete narratives are really what's important to get at the letters, to really make a compelling case, and convince USCIS that you do have extraordinary ability in your field, or that your work does have national importance and you are well positioned to advance the endeavor. All right, so then we will now talk a little bit about some strategic considerations. Which category should I apply for? So the first question to really ask when you're deciding between those options that we discussed, the O-1 options, the EB-1A, the EB-2 NIW. So the first question is, do you want to stay in the United States temporarily or permanently, right? And as Kelly mentioned before, the O-1A and O-1B are both temporary non-immigrant visas and are well suited for people who, have work arrangements in the United States, but, either they also have strong connections to their home country. And maybe you need to travel back and forth frequently. Maybe maybe you need to stay for long periods of time in your foreign country, and you would like that freedom to go in and out as much as you want. Now, the EB-1A and NIW are both green card categories, and this is really well suited for people who want to live in the United States permanently. And once you get the green card and once you spend, 5 years of, living in the United States, you can also potentially apply for citizenship. And if that is something that you want in the future, the EB-1A and NIW are pathways towards that kind of goal. Now, being a green card holder, being a permanent resident also comes with responsibilities. And one of the things is that there is a limitation on how much time you can spend abroad without abandoning your green card, basically, right? So if you're someone who, needs to really have that strong connection to your foreign country, maybe the green card category may not be the best option for you. So definitely, the important question to ask is, what is your intention in the United States? Do you want to stay there permanently, or are you really looking for a temporary work option? Now, the second consideration we really want to think about is your connection to the United States. Do you have a US agent or US employer, or even a US corporate entity that you can use as the petitioner? Or do you want to self-petition as a foreign national himself or herself as an individual? Now, formally, technically, the O-1A and O-1B visa does require a U.S. agent who is, a person who is living in the United States and typically is a U.S. citizen, to kind of drive the petition forward and act as the petitioner, being the agent for you and any other employers that you may work with in the United States, or a U.S. employer itself. So you can, if you have a company that is giving you a job offer, or if you have a U.S. company that, if you're an entrepreneur and if you found a U.S. company, that U.S. company can act as the U.S.-based petitioner to drive forward the O-1A and O-1B. But the distinction is that it is not yourself as an individual who's doing the application. It's the separate legal entity, which is the U.S. entity that's driving forward the case. So there is that technical difference. Now, the EB-1A and NIW both are green card applications that allow self-petitioning, as I mentioned before. That means the foreign applicant themselves can be the one who are applying. You don't need a U.S. entity to drive forward the case. You do not need a U.S.-based job offer. So that can be another consideration. You have an EB-1A and NIW. You can drive this forward even if you are completely from outside of the United States. You can, go through what is called the consular processing from your home country, and you can also apply for immigrant visa from there. So for people who are completely based on a foreign country, EB-1A and NIW could be something to consider. So the last thing I would talk about here are family considerations, right? So as Kelly mentioned before in the previous slides, for the O-1A and O-1B, spouses and children are allowed to accompany the principal on O-3 visas. However, work authorization for spouses is not available. So the spouses and children can study in the United States, but there is no work authorization. And so if the spouse needs to work in the United States, this may not be the best option. For the EB-1A and NIW, they're both green card options. So spouses and children under 21 unmarried can also apply for green cards as dependents, and which means the whole family can, become permanent residents, practically, right? And if you are applying to adjust status in the United States and filing what is called an I-485, the spouse can also do that and can apply for work authorization and travel authorization. So those are benefits that are available for all I-485 applicants, and your spouse can also get those benefits, which can be a significant advantage for some people. All right, now let's think a little bit about then strategic considerations when you are moving from a non-immigrant visa to a green card. So the first thing to think about are the differences in qualifications that the government will expect, right? Practically, the government looks at an EB-1A petition with a higher standard as opposed to judging an O-1A or O-1B, even though the regulatory language are quite similar. Practically, the scrutiny that the government gives for an EB-1A case is very high. So that just means that qualifying for an O-1A or an O-1B does not mean that you automatically qualify for an EB-1A. It may be strategically a good idea to really strengthen your case, strengthen your profile before applying for an EB-1A, even if you already do have an O-1A or O-1B, especially if you're jumping from an O-1B to EB-1A. So an O-1B, as Kelly mentioned, has a slightly lower standard, requiring a distinction in the field for the arts, for example. Going from that distinction to an EB-1A, which requires being, one of the few, small percentage of people who have reached the very, very top of the field, that can be a big jump. So definitely I would consult with an experienced attorney, have them review your credentials, and if need be, if you need to bolster your profile, bolster your portfolio to have more compelling and robust evidence that will really get you to the EB-1A level, that can be, a long-term strategy you can have, spend a couple of years really strengthening that profile before applying for the EB-1A. The other strategic consideration you want to think about is timing. So consider how much time is left on your current underlying visa, because some visas are harder to extend or subject to more scrutiny once you have filed an immigrant petition for, for example, the EB-2 NIW petition or an EB-1A petition. If you have filed that kind of thing, for some visas, you may encounter more trouble renewing them. For example, the TN visa is a good example. If you have a TN visa and you file an EB-2 NIW, for example, and you try to renew the TN visa again at the border, you may get questions from the officer on your immigrant intent, because filing an I-140 can be taken as an expression of immigrant intent. Definitely talk to your attorney if you're considering these strategies, and we can advise you on the risks, so you can make the best decision that works for your case. Family considerations. So if you have children who may also need the green card, it may be in your interest to file, an immigrant petition more earlier than you usually would have had to, avoid issues with children aging out and no longer being qualified to qualify as dependent for the green cards. All right, so I believe this is the last topic we'll cover is the question, are extraordinary ability categories available for entrepreneurs? And the answer is yes. And there are a few points why this can be a good option. So the first point to make is the EB-1A and NIW, as I mentioned before, are green card categories that both allow for self-petitions, meaning both are possible options for entrepreneurs who may not have a US-based job offer, who may not have a US entity that can sponsor them. The second thing to note is that there have been changes in the national interest waiver standard under matter of Danisar, which made the NIW a much friendlier category for entrepreneurs. And there were updates to the policy manual, the USCIS policy manual in 2022, which really expanded upon the types of evidence that can be considered by the government when they're looking at a case on behalf of an entrepreneur. So really, the EB2 NIW category became, a viable choice for many entrepreneurs compared to before matter of Danisar came about. The final point that we would like to make here is that it is possible to apply for an O-1A visa as an entrepreneur, a business person of extraordinary ability. It's just that you must have a separate corporate U.S. entity set up in the United States that can act as the petitioner, and you do need to show some sort of, ongoing, potential work arrangements in the United States in the form of, expert, in the form of letters of intent or, client contracts and things like that. But provided that you have that, it is possible for you to, apply for the O-1A through that corporate entity that you will set up because it is considered a separate legal entity as long as that is a U.S. legal entity. All right, so we will now look at questions and answers to see if anyone has specific questions to discuss. It doesn't seem like we have any. All right, so in this case, I thank you all for your time joining us today. I thank you, Kelly, for sharing your expertise, and hope to see you all at the next webinar. Thank you.